Firstly, the conduct must be repeated. So what that means is that even a very serious incident of unreasonable conduct will of itself not qualify as bullying. So it needs to be repeated. It doesn't necessarily have to be the same class of unreasonable conduct. It could be a pattern of conduct, but it must be more than one event. Secondly, the conduct must be by an individual or a group of individuals, and it must be directed towards the applicant worker or the group of workers to which the applicant belongs. The next qualification is it must occur whilst the applicant is at work. Now, at work means, in essence, whilst they're at the workplace or wherever the applicant worker goes whilst they're performing work. So there are two other qualifications as well. Firstly, the unreasonable conduct not only has to be repeated, but it must create a risk to health and safety. So that's an important qualifier, that not all unreasonable conduct qualifies as workplace bullying. It must be such as it does create a risk to health and safety. And lastly, the definition also notes that workplace bullying is not reasonable management action taken in a reasonable manner. And the intention of that appears to be to acknowledge that managers and supervisors have the right to conduct the workplace and to make reasonable management decisions, and providing that is done on a reasonable basis, that's not going to be workplace bullying. So look, that's the definition under the Act.